Your product hits 4 stars, 2,000 reviews, and a bestseller badge. 2 months later, Amazon Basics launches the exact same thing for $4 less. You didn't get a warning. You didn't get a call. You just watched your sales rank collapse in real time. This isn't a rumor. This isn't a fringe complaint on a Reddit thread. This has happened to thousands of real sellers, and it's happening right now. Meet the kind of founder this happens to. Someone who spent 2 years developing a product, tested it, sourced it, and built a real customer base on Amazon's platform. They did everything right, optimized the listing, ran the ads, collected the reviews. Amazon's own platform told them they were winning. Then one morning, a new listing appears at the top of their own search results. Same dimensions, same use case, same target customer, Amazon Basics logo in the corner. Hopefully you found this video helpful. It's sponsored by IP Clutch. I tried filing a patent myself and spent a lot of money without understanding the results. That's why I built IP Clutch, an AI tool that helps you check if your idea is patentable, create proper documentation, and guide you through filing. Everything a patent attorney charges thousands for, starting at just $99. Most inventors never file because they're unsure or can't afford the process. IP Clutch gives you that clarity for free. No credit card, no attorney, link in the description. The founder's first instinct is to fight back. Call a lawyer, file a complaint, demand Amazon remove the listing. Here's what they find out. There's nothing to file. Amazon didn't steal their product, they didn't counterfeit it, they built a different product, inspired by every data point the founder willingly provided. And here's the twist that changes everything. The data Amazon used to build that product, the founder handed it over, voluntarily, on the day they listed. Amazon's seller agreement gives them the right to aggregate and use sales data across the platform. Click-through rates, conversion data, which keywords convert, which price points win. Most founders treat that agreement like a terms of service checkbox. It isn't, it's a blueprint transfer, and you signed it before you made your first sale. This is the part where most people ask, isn't that illegal? Isn't there a law against this? That's exactly the right question. And the answer is the most uncomfortable part of this story. Here's what makes this maddening. Amazon didn't break a single law, and they knew exactly what they were doing. When you list a product on Amazon, you sign something. Most founders treat it like a terms of service checkbox. It isn't. Amazon's Business Solutions Agreement is over 9,000 words. Most sellers spend less than 60 seconds on it. Buried inside is a clause that grants Amazon a royalty-free, irrevocable license to use data generated by your activity on their platform, your clicks, your conversions, your pricing history. That isn't abstract. Every time a customer views your listing and doesn't buy, Amazon logs it. Every time someone adds your product to their cart and chooses a competitor, Amazon logs that too. What Amazon ends up with isn't just your sales numbers, it's a real-time map of exactly what your customer wants and exactly what your product fails to deliver. Here's where it gets precise. Amazon can see which price point converts best in your category, which images stop the scroll, which bullet points close the sale. They don't need market research, they have yours. And none of this is secret. Amazon disclosed it in the agreement you accepted. Now here's the part most people miss, and this is the real twist. Amazon doesn't even need to copy your product to destroy your business. They just need to own the search result above yours, and their algorithm already decides who wins that, before any customer makes a single choice. Amazon controls the search algorithm. Amazon controls which products get the Amazon's Choice badge. Amazon controls sponsored placement, and Amazon Basics doesn't have to pay for ads on Amazon's own platform. This is the part where sellers start to feel it. Not just the clone, but the platform itself working against them. The rules of the game changed, and they're still playing the old version. Some sellers try to fight back by pulling their listings entirely, but by then, the damage is done. The data was collected the moment they went live, not the moment they quit. The data is theirs the moment you list, but data isn't the only weapon. The next one is something Amazon never even has to touch. 3 tools exist to protect your product: a utility patent, a design patent, and trade dress. Most inventors confuse all 3 and end up protected by none of them. Let's start with the one everyone thinks they need. A utility patent protects how something works, a specific mechanism, a specific process, a specific function. If you invented a new kind of hinge that locks at a specific angle, you can patent that hinge, not the door, not the room, the hinge. That matters because most products people sell on Amazon aren't novel mechanisms. They're existing categories with better materials, better sizing, or better branding. A utility patent won't cover that. Next, the design patent. This one protects the ornamental appearance of a product, not how it works, what it looks like. Apple's original iPhone home screen layout, the Crocs clog silhouette, the Coca-Cola bottle shape, these are design patents, protecting a look so specific and distinctive it became the product. Here's the problem. A design patent only protects that exact ornamental design. Change the curve, adjust the angle, swap the texture. Legally, it's a different product. And this is where the key twist in this whole story lives, so pay attention. A patent protects a specific mechanism or ornamental design, not a market category. Amazon can sell a product that functions identically to yours, looks nearly identical to yours, and targets the exact same customer, as long as they change one non-essential feature and call it something different. Now, trade dress. This is the one most founders have never heard of, and it's the most misunderstood protection of the three. Trade dress protects the total image and overall appearance of a product, the combination of color, shape, packaging, and visual presentation that makes customers recognize your brand at a glance. Think about the Tiffany blue box. Nobody owns that shade of blue in general, but Tiffany owns it in the context of jewelry packaging because the total image has become the brand. Trade dress is harder to strip away than a utility patent because it's not tied to one feature, it's tied to recognition. And recognition is built over time, which means it compounds. But here's the reality check. None of these protections, utility patent, design patent, or trade dress, matter if they're filed after Amazon already has your data. Timing is everything. Here's the brutal math. The average utility patent takes 3 years and $15,000. Amazon can clone your product in 90 days. The timeline alone is the loophole. In 2020, the Wall Street Journal published internal Amazon documents. What they described wasn't a rogue team acting alone, it was a process. The documents showed employees inside Amazon's private label division accessing data on individual third-party sellers, not aggregated platform trends, specific sellers, specific products, specific numbers. This matters because Amazon had publicly stated, repeatedly, including to Congress, that they do not use individual seller data to inform private label decisions. That gap between the public promise and the internal practice is the twist at the center of this whole story, and it changes what platform risk actually means. Here's how the playbook actually worked step by step. First, the private label team identified high-performing categories, not just any category, ones where a third-party seller was already proving the demand. Second, they pulled the individual seller's unit sales, margin data, and return rates, the information that tells you not just that a product is popular, but whether it's actually profitable to manufacture. Third, they used that data to spec a competing product, matching the price point that converts, addressing the complaints buried in the reviews, and cutting the features customers didn't actually value. Your negative reviews, the ones you were trying to fix, became their product roadmap. Every complaint your customers left in public became a free engineering note for the competition. The FTC noticed in 2021 they opened a formal inquiry into Amazon's private label practices. Amazon cooperated, submitted documentation, adjusted one internal data policy, and then the practice continued under a different name with a different team. The playbook didn't stop, it got quieter. This is the midpoint of this video, and if you've made it here, what you now understand is something most Amazon sellers never figure out until it's too late. The risk isn't just that Amazon might copy you, it's that they have a documented, systematic process for deciding who to copy, and your success on their platform is what puts you on the list. Winning on Amazon, getting the badge, climbing the rank, earning the reviews doesn't protect you, it targets you. This isn't a flaw in the system, this is the system, but knowing the playbook is the first step to playing a different game. Stop asking how to beat Amazon in court. Start asking what you can own that Amazon legally cannot touch. There are 3 windows where founders have real leverage. Each one works at a different stage, and only one of them is still open after the clone is already live. Window 1, file a design patent before you list, not after you hit traction, before the first listing goes live. A design patent application can be filed in weeks, not years, and the moment you file, you have patent pending status, which creates a legal record that your ornamental design existed before anyone else's. That filing date matters more than the granted patent. In IP law, priority goes to whoever filed first, not whoever built first, marketed first, or sold first. Design patents cost between $1,500 and $3,000 to file with an attorney, and they issue in roughly 18 months. That's still faster than a utility patent, and the protection kicks in from the filing date. Window 2. Build your brand off Amazon before the clone appears, not instead of Amazon, alongside it. Amazon can clone your product. They cannot clone your customer relationship. An email list, a community, a loyal audience, those are yours. Amazon cannot suppress them in a search algorithm. Every founder who survived a clone attack had one thing in common: customers who knew their name before Amazon entered the category. Brand equity is the moat Amazon cannot fill. Window 3. This is the one most founders miss entirely, and the only one still available after the clone is already live. Trade dress protection, the look and feel of your product's total image. Not one feature, not one color, the entire visual identity registered as a legal asset. Here's the twist. Trade dress is harder to strip away than a utility patent because it's not tied to one feature a competitor can engineer around. It's tied to recognition, and you can keep building that recognition even while a clone is on the market. And here's what almost no one knows. Trade dress registration through the USPTO can move faster than a utility patent, especially if you can show that your product's appearance has acquired distinctiveness in the market. The founders who file trade dress claims after a clone appears can argue that the clone itself is causing consumer confusion, which is actionable under the Lanham Act, even without a pre-existing patent. Window 3 is the one most founders miss entirely, and it's the only one that works after the clone is already live. But it only works if your brand's visual identity was consistent enough and distinctive enough to register. That's the bar. Start building toward it now. One rule: file before you list, not after you hit bestseller, not after you see the clone, before you list. This is the one move that separates the founders who have legal standing from the ones who don't. Everything else in this video leads here, but here's where most founders make the mistake. They assume the first step is filing. It isn't. The first step is searching. Before you file anything, you need a prior art search. This is a structured review of every existing patent, published application, and public disclosure that might relate to your product. And here's the twist. Most founders never see coming. A prior art search doesn't just tell you if you can patent your product. It tells you if someone else already patented it and whether your product is the one at legal risk. Amazon holds thousands of active patents, so do the manufacturers they work with. If your product lands inside an existing patent claim, even accidentally, you're not the victim, you're the infringer. This is the legal reality no one tells you before launch. You can build something original, invest everything in it, list it on Amazon, and receive a cease and desist letter instead of a bestseller badge. So the pre-launch IP checklist has 2 jobs. First, confirm your product is clear to sell. Second, establish your own IP position before anyone else can claim priority. Step 1 of the checklist: run a prior art search across USPTO, Google Patents, and international databases. You're looking for anything that could block your filing or expose you to infringement claims. Step 2, assess patentability. Is your product novel? Is it non-obvious? Does it have a distinctive ornamental design worth protecting? These aren't subjective questions. They have legal definitions, and they determine what you can actually file. Step 3, file the right protection for the right part of your product. A design patent for the appearance, a utility patent if there's a novel mechanism, a trade dress claim if your brand's visual identity is already distinctive. These aren't mutually exclusive. The problem has always been access. A proper prior art search from a patent attorney costs $1,500 to $3,000 before you've made a single dollar. Most founders skip it because they think they can't afford it. That's the gap IP Clutch was built to close. IP Clutch runs the prior art search and patentability analysis that founders need before they list, using AI trained on USPTO data at a fraction of the cost of an attorney. You get a prior art report, a patentability assessment, and documentation you can hand directly to a patent attorney if you decide to file. The search that used to cost you $2,000 in 2 weeks, IP Clutch starts at $90. Most inventors wait until after the damage is done. The ones who don't, they ran the search first. That's the difference between owning your product and funding someone else's. Link is in the description. Run it before you list. Here's your move, not a checklist of 10 things. One move, run the prior art search before your product goes live anywhere. Everything in this video, the data trap, the playbook, the 3 windows, all of it collapses into one decision point. Did you search before you listed or didn't you? If your product isn't live yet, you're in the best possible position. The window is open. A prior art search right now costs less than your first ad campaign and protects everything that comes after it. If your product is already live, don't stop reading. Run the search anyway. You need to know if you're inside someone else's patent claim before they tell you with a lawyer's letter. Go to IP Clutch, describe your product. The AI runs the prior art sweep across USPTO and international databases, flags anything that overlaps, and gives you a patentability read in minutes, not months. The report tells you 3 things: what's already out there, whether your product can be protected, and what type of filing makes sense. That's the conversation you'd pay a patent attorney $300 an hour to have. IP Clutch starts at $99. Link is in the description. No credit card required to start. You can run the free patentability check right now, before this video ends, before your listing goes live, before any of this becomes your problem instead of your prevention. Most inventors wait. They wait until the clone appears. They wait until the lawyer calls. They wait until the sales graph looks like the one you saw at the beginning of this video. Don't be that founder. Amazon built a machine to find your best ideas and legally take them. Build the one thing that machine can't touch, a filing date that predates everything they do next.